I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are running through door number 152 on our compilation list. Before I give you the rundown of the 3 different judges' courtrooms we will be in on today, know that there will be chapters added for your convenience. Commentary will be in this compilation from some of these previous proceedings. Also, don't forget to like, comment, share, and subscribe. Now, the 3 judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Brian Oakley out of the state of Michigan. Second, we will be in the courtroom of Judge Abbey McMahon out of the state of Washington. And last but not least, we will be in the courtroom of Judge Jennifer Grant, also out of the state of Washington. As always, thank you for joining me for this compilation. And it's about that time, guys, to head into 152.
Matthew, is it Crucell or Crucell?
Crucell.
Crucell, come on up. Actually, we've got a motion today, don't we?
We do.
You got a motion filed?
Yeah, oh yes, absolutely. I actually have issues to discuss before I cross.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually project word that since unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front second.
That's fine. Just make sure you talk to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying
Okay,
to
well,
be
which one
dismissed.
do you want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out and passed it, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that
too
stuff.
many issues. You're talking about swearing in, you're talking about a default judgment. Which, just pick one issue. We're gonna deal with them one at a time. So what do you want to deal with first? You want to deal
Well, my
with the
main motion.
default?
Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting.
I mean, that's
set
the only
aside, so
civil
I
infraction.
have numerous,
Hold
I
on,
have lots of stuff.
Hold on,
going
that's
here.
the only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yes,
about
it was over
that
the-
charge.
Yeah, sure. It was over
Okay.
that.
So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified, I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation, there was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in
Okay,
the
hold
order.
on, hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I
of the
said
ticket.
it's in there, it's attached to my motions.
Okay, do you have a copy
Yes,
of the ticket?
I do.
Okay, then I'm gonna ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before, there's nothing.
Okay,
They
but
didn't
it
give me no
says,
time frame.
it says contact court for appearance date. That
How
means the
long?
monkey's on your back to contact us.
I will also on the bottom of the tickets, it says, if you fail to contact court within the specified amount of time, there was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my
Well, let me
attorneys.
ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Crucell,
contact the
Mr.
court.
Crucell, this is gonna go a lot easier on everybody if you just answer the question I asked. I'm gonna give you plenty of chance to give me any argument you wanna give, okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm gonna take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting
Well, once
attorneys.
again, I'm gonna draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received it?
This told me, this said I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than a
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
well, once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay,
There was no dates.
okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default in the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No,
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I
No,
object
no,
to
no,
this-
no, no, wait, listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to
No,
issue
no, no.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants. would
How
be
was that
issued for my
damage?
arrest. And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money or I would have been, there'd been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to me
Stop.
about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new showdown overlay, that's just saying that she's just trying to set it aside, that there's no issues. with
She
the
didn't try
court.
to set it aside, she sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
I don't
No,
think so.
she never did. No one did. I
Sir.
explained in my motions.
Sir, I'm gonna hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm, the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right? So we started with, what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some
of.
point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more. Do you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my motion.
object. You can appeal.
But I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honest, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we are in Sibley and Middlebelt, right near actually to where I got pulled over. And we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that
specifically
a fair
stated.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional freedom. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which
So
I object to the.
hold on. All right. So the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license.
That's
Okay.
correct.
All right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So
Right.
hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not gonna plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes
with
or
that.
no? Mr.
Yes, I agree
Vito?
with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reason?
Yes, I actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling
understand?
it an
Sir,
ORV.
your objections mean shit, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care, all right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label my private property as an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand
I don't
that.
think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it was like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
He's witness to that as
Mr.
well.
Purcell,
So again,
with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
well,
right?
the officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws. Or
That
the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions at trial?
Well, honestly, in the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, and as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own
But
recording.
sir, stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. Okay. So was the $280 posted as a bond when the initial default happened?
I believe so. I know.
Do you
that-
have any record of $280? Because we're not getting receipts in the files anymore.
I have the receipt right here, Your Honor.
Okay. I'll return your 280 today. Anything else today? All right, let's talk about a date for jury trial.
Caitlin, do you want August? What did you say? Sixteenth or 23rd? Which one would you like?
What was that?
September 16th or September 23rd? They're both Mondays.
Maybe 23rd.
23rd?
8:30. All right, now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might say that. You don't understand the rules.
I do.
Okay? How many jury trials have you had?
none, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can, and that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right?
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else?
Okay.
Have a nice day.
Thank you.
This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris appropriate persona. I've challenged the jurisdiction of this court, and I don't understand, so I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so? You
I don't
know?
have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying, is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is assessed a case trust action, which you are a real party in interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud, trust?
I'm saying that you are subject to
This-
the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice, because this is a commercial matter. I'm a non-US citizen, American national, by way of American Samoa. I'm beneficiary. I am here sui juris and propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So this man cannot speak for me. Like
Okay,
I said.
he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter. But it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please do
Schuster?
not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or Sisticate trust action. And so I'm here sui juris and propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
going to represent me. I can present myself, as I
Okay.
said.
So you want,
initially.
so you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you, I'm here sui juris and propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial and suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further, because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is your position, because
it's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
argument.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July 1st.
That date doesn't work,
Why doesn't it work for you?
because I'm a man. I have things to do. I've come here multiple times under duress with threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back on July
Are you
1st,
threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't show
Are
up.
you
So
threatening me now?
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st.
Would you like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m. back in
Now
this
you're
courtroom.
threatening me. Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for
You
this week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're going to threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you
No,
your
I'm telling you
options.
this matter needs to be dismissed with prejudice, because you cannot prove jurisdiction. This is a
Signature
Sisticate
here.
trust action.
Signature
You're
here,
trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now.
I'm
even more
giving
so
you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed. No, I have.
Let's address. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to and give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I
reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel. Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Troy Colin Schuster, am here under fraud, menace, and duress. I've made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
Well, right now,
to answer them?
I am not here to be interrogated by you. You are under the jurisdiction of this. I think you understand and you choose not to take in the information. Okay, well, Mr. Schuster.
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right in my proper person. He does not have my permission to represent me in any way.
Well, it doesn't sound like you know how to represent yourself either, which you would
represent myself.
Well, you would. Either you have counsel or you are acting pro se.
Myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction or is this an admiralty maritime jurisdiction?
Either. So, Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record,
if you would like,
if you step up so you can hear me better, and I will speak louder. I will speak louder so you can hear me, but I reserve all my rights, and I'm speaking much louder than anybody else prior to me has spoken. So Schuster, I just want to make sure that the reporter can hear me.
You are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will begin again so that the recorder can hear me.
You're not choosing to be silent. You're choosing to make a legal argument. So we need to have that on the record.
For the record, I reserve all rights.
You've made that.
I, Jonathan Troy Colin Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestakay trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand, and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect that is causing you to not be able to
challenge my competency because I have challenged the jurisdiction of this court, and you have not proved jurisdiction.
In Social Security or contract
you
or
have to
maritime.
prove jurisdiction before we can move any further.
So that's just not how it works in this court, and
No,
I don't think you have the legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you prove
I'm Judge Grant, so I'm going to have you.
Can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training, so that I think is
that does not matter.
Well,
if I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody, and we cannot move further until you've proven jurisdiction.
So, Ms. McDonald, what I think would be the next steps, I don't know if Mr. Perrin, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw his.
So we could go through the colloquy. We can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Oh, absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We
that.
have a speedy trial at August 9th.
It is the burden of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from counsel so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, this should be a.
You've failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Right. So Mr. Schuster, did the court say that was end of August, or?
It was August 9th is speedy trial.
Okay. So.
And if you plan on having me back here, you're taking away from my ability to provide and work. And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom court available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
Does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are subject to another court, and they could very well
get in trouble. And you have to prove jurisdiction. You haven't done that, and you failed.
Obviously,
to do that
you
over
believe
and
that
over and
courts
over
do
again.
have
And
jurisdiction over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is, and this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead, because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity. And that's ridiculous for what's going on here. That's absolutely ridiculous. And so
I don't think
this matter
anyone
needs
is
to be
told that you're
dismissed
being
with
put
prejudice.
into captivity.
And whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead. But obviously you can't prove jurisdiction. So
I'm looking for the more
waste everybody's
detailed
time, please.
counsel
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet.
No, he hasn't. I have a streamlined version, but I want him the formal,
The detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines. And so your rights need to be protected. This is for your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my rights. And if you're going to acquiesce, then okay, you're proving that you don't have any jurisdiction.
So this is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I've said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right in my proper person. You know what that means.
So there's the form.
I've never signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of line, Mr. Schuster.
I didn't say anything disrespectful.
You are being very disrespectful.
You are being very disrespectful, actually,
because
you're violating my rights.
So I'm going to set this on for the August term. I'm going to have you take this form.
Wasting my time.
Mr. Schuster.
And you're taking away my ability to provide and work. Because
Have a
this is
seat there so
free-
you can fill out
free
this
place.
form.
What's that?
You can have a seat there so you can fill out the form.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're gonna have to go through that because this case is gonna be going to trial. It's gonna be set on the August term. That would be August 6th, and that will be at 9 a.m.
All right, you're dismissed.
No, you're not free to leave yet, Mr. Schuster.
I'm not free to leave.
Not yet. No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be
Yeah,
dismissed.
it's not going to be dismissed right now. So
That's
right now it's getting
dismissed
set
because
for
you cannot
trial.
move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m.
don't
And
have
that
any-
hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you
Over and
choose
over
not
and
to
over.
come to your court hearings, a warrant will
Over
issue
and
for
over
your
again. And you're
arrest.
threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening?
Could you go back there?
We can set a pre-trial. Let's do it on the 22nd.
The prosecuting attorney also needs to provide any contracts that I've entered into internationally,
Here's your court date. Could you
Uh,
please sign for that?
especially if this is a admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So
Mr. Schuster, you are in a criminal court and there are court rules. If you wish
criminal
to
matter,
have,
this is a criminal matter, you said?
Mr.
This
Schuster,
is a criminal matter?
if you wish to have discovery, then you need to abide by
You said
the
this is
rule.
a criminal matter?
Yes, and if you
Yes,
wish to have,
these are-
Oh, okay. I wasn't sure you said that. Thank you.
it's a criminal matter. If you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an admiralty maritime jurisdiction?
No, we are not. Mr.
Are we under
Schuster.
a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery, then you need to request.
Unless I give you my
discovery.
permission to be under that jurisdiction, which I haven't.
You will need to request discovery from the prosecutor's office.
I'm not a U.S. citizen, American national. That's not a jurisdiction.
If you wish to have discovery, you need to request it in writing from the prosecutor's office, and we will
You said
send.
your nationality was a U.S.
And then we,
Is that what you
and then
said
we will,
earlier?
and then we will send you the discovery, of all of the evidence that we have against you at trial. Did you understand that?
I don't understand what's
Okay.
going on with this.
So,
This is ridiculous.
here's my
Kangaroo
suggestion,
court.
Mr. Schuster.
Kangaroo
Mr.
court. And so
Mr.
since you
Schuster.
guys are gonna waste everybody's time even more, goodbye.
Mr.
Mr. Schuster, you need to sign for your court dates. I'm giving them to you orally.
You have a good day. Talofa.
If you don't appear for your court hearings that were given today, a warrant will issue.
Well, guys, we've come to the end of these two proceedings. And yeah, you guys were right. Mr. Jonathan Schuster is definitely a handful. Like I said, I'm still feeling a little under the weather, so I'm going to try to make this short and sweet. But what I will say is the lawyer seemed like in that first appearance that he had enough of Mr. Jonathan, because when Jonathan told him to just dismiss himself, I don't know if you guys caught it, but the lawyer told him to shut up. So we see that, not only are the judges sick and tired of the stuff that he's doing, but the lawyer, the attorney that's supposed to be trying to help him, is just fed up with it as well. And even in that first appearance, him talking all the junk that he talked, and then, when it came to him being reprimanded, all of a sudden he comes to his senses and he wanted to cooperate. But I'm gonna be honest with you guys. I've done a good amount of these videos, and obviously we've seen people that should be held in contempt, people that have been held in contempt. And I've never said this about any, sovereign citizen that I've covered before. whether they should be held in contempt or not. But this guy, I don't know how on God's green earth they did not hold this man in contempt for all the disrespecting and talking over and talking crazy. Even the sheriff in the second appearance, I mean, he's just standing back there like, you know, whatever. I mean, some courtrooms, a Judge Simpson, you know, excuse me, some of the courtrooms like that, like there's no way that this is going to go on. But like I said, he definitely was a whole lot to handle, maybe for them, but I think for other judges, he wouldn't have been. I don't know if I'm going to follow up with this. Like I said, it came to my attention. I checked it out. I definitely think it was definitely pretty wild to see. With that being said, guys, hopefully next time I jump on these videos, I'll be feeling a lot better. With that being said, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys.
I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.